Gresham College presents Privacy and Publicity in Family Law, Their Eternal Tension by the Right Honourable Sir Nicholas Wall.
Good evening, my lords, ladies and gentlemen. I'm Roderick Flood, the Provost of Gresham College, and it's my great pleasure to welcome you here to the annual Gray's Inn reading. This is one of the established and much valued features of the Gresham year. It's therefore one of the 150 or so lectures which form part of the academic programme of the college. And like a number of others in the programme, it's a collaborative effort with Gray's Inn, and we very much welcome that collaboration and the collaboration with other institutions. We bring to those collaborations this rather lovely venue, hall, our usual enthusiastic and I'm sure well-informed audience, and also, of course, our worldwide audience, now over 1 million strong, who access our website and download our lectures each year. And you can in fact find, you and they can find all the recent Gray's Inn readings back to 2004 on our website. Our speaker this evening, Sir Nicholas Wall, continues a tradition of most distinguished members of the legal profession who've given the readings over the past years. He's been President of the Family Division and Head of Family Justice for England and Wales since April 2010. He was called to the bar in 1969, took silk in 1988, was appointed as a judge in the Family Division in 1993, and to the Court of Appeal and the Privy Council in 2004. He's become known for expressing firm opinions on the field in which he's become so expert. He's argued, for example, for the introduction of no-fault divorce, to recognise that divorce is, as he put it, now an administrative rather than a judicial process in which the concept of guilt or innocence has no place. And he's also recently warned of the dangers to the family law system caused by the imminent cuts to legal aid. And tonight he takes on an equally controversial topic: privacy and publicity in family law, their eternal tension. As the husband of a social worker and family court magistrate, I recognise a topic which has often been discussed in our household, and I'm very much looking forward, as I'm sure we all are, to hearing Sir Nicholas's view.
Thank you very much. It's a pleasure to address so sensibly accoutred audience. I feel grossly overdressed myself. I'm reminded of the time when I went as a young barrister with a leader to Holloway Prison to interview a female defendant, and he was slightly concerned by the shout, "Get him off! Get him off!" as we walked in through the front doors. I rather feel like that with my dress as I am this evening, so please forgive me. I'm very grateful for the introduction. It is a controversial topic, and I'm afraid I may not know the answer, but I'm going to put some ideas to you. There appears to be a general agreement amongst non-family lawyers, and also I have to say amongst some family lawyers, that family proceedings should be more transparent. We recently had a report from the House of Commons Home Affairs Committee which recognised the need for transparency in the administration of family justice. It was very critical of the previous government's attempts to reform the system under Part 2 of the 2010 Act, Children's Schools and Families Act, and I noticed that the Family Justice Review joined in, as did the government, and decided that the Act would join the long list of not very distinguished Acts of Parliament which have been repealed in family justice before they've been put into effect. So we start again from the drawing board. The position was summarised by the Select Committee in these words: there is a tension between allowing the media to publish even limited material about cases in the interest of increasing public confidence, and a child's right to keep personal information about them and their experiences private. There is a danger that justice in secret could allow injustice. We believe that the underpinning principle of the family court system, that all decisions must be made in the best interest of the child, must apply equally to the formation of government policy and media access to the family courts. Those are fine words, but they emphasise one of my themes this evening, is that no one knows quite how to make family justice more accessible. As I say, they are fine words. How do we put them into practice? Family lawyers are divided on the issue. I make no secret of that. On the one side are those who take the view that any publicity involving the affairs of disadvantaged children and adults is unwarranted. The media is unashamedly sensationalist, quite apart from being anti-judge, and that children and their families are entitled to privacy when forced to litigate about the intimate detail of their lives. At the other extreme, there are those weary of the constant refrain that family courts practice secret justice, and an equally constant refrain that children can be removed from their parents at whim unless there is media scrutiny. The consequence of this secret justice, it is argued by those who use the phrase, is that social workers, judges, and all engaged in the family justice system are both unprincipled and autocratic, as well as riding roughshod over the parents' ECH Article 8 rights. ECHR Article 8 rights. So there we have what I have called in the title of this paper, the eternal tension. The question which arises, of course, is whether the two positions can be reconciled, whether there is a workable solution to the problem. The purpose of this paper is to see whether that solution can be begun. Of course, the simple answer would be to bring family justice into line with civil and criminal justice. There are occasions, of course, when anonymity is practiced, but they are few and far between. The print media usually have free admission to such proceedings and are on the whole free to report what they wish. Proceedings are usually conducted in open court. There are few complaints from either side. One of the questions, therefore, is whether that system can be adapted to family justice. Would that it were so simple. So where should one start? I'm going to try to get into the debate by reminding myself of two of the three basic propositions which I learned at school about the freedoms we are said to enjoy in this country. The first is a free press. The second is a judiciary independent of government, administering justice in private. No doubt there are other propositions, including something about free and fair elections, but those two will be enough for me to go along with. So what are the arguments against transparency? Yes, of course we must administer justice in public. The reasons for that are self-evident, and I'm sure I needn't weary this audience with them. However, in the same breath, we are constrained to recognise that there always have been exceptions to the general rule. And I propose to start this element of the debate by looking at what the Lord Chancellor said in the well-known case of Scott and Scott back at the turn of in 1913, in the turn of the 20th century. The language is archaic, but the ideas seem to me quite modern and sentiments equally clear. The case, he said, of wards of court and lunatics, that's the dating bit, stands on a different footing. There the judge who's administering their affairs in the exercise of what has been called a paternal jurisdiction delegated to him from the Crown through the Lord Chancellor is sitting not merely to decide a contested issue. His position as an administrator as well as judge may require the application of another and overriding principle to regulate the procedure in the interests of those whose affairs are in his charge. In order to make my meaning distinct, I will put the proposition in another form. Whilst the broad principle is that courts of this country must, as between parties, administer justice in public, this principle is subject to apparent exceptions, such as those to which I have referred. But the exceptions are themselves the outcome of a yet more fundamental principle, that the object of the courts of justice must be to secure that justice is done. In the two cases of wards and lunatics, the court is really sitting primarily to guard the interests of the ward and the lunatic. Its jurisdiction is in this respect parental and administrative, and the disposal of controverted questions is an incidental only in the jurisdiction. It may often be necessary, in order to attain its primary object, that the court should exclude the public. The broad principle which ordinarily governs it, therefore, yields to the paramount duty which is the care of the ward and the lunatic in question. As the paramount object must be always to do justice, the general rule must always be that publicity, after all, which is only a means to an end, must accordingly yield. There are, of course, many other relevant passages in the speeches in this case, but this extract will serve for present purposes. The sentiments expressed in Scott and Scott have found parliamentary expression in a number of forms, notably the Administration of Justice Act 1960, the Children Act of 1989, and the Children and Young Persons Act of 1933. In the interest of time, I won't give you the citations from the three acts, save I think it's important to just remind you of what the 1960 Act says in section 12. The publication of information relating to any court sitting in private shall not of itself be contempt of court, save in the following case, that is to say, where the proceedings, 1, relate to the incident inherent jurisdiction of the High Court with respect to minors, 2, are brought under the Children Act 1989, or 3, otherwise relate wholly or mainly to the maintenance or upbringing of a minor. Without prejudice to the foregoing subsection, the publication of the text of the summary of the whole or part of an order made by a court sitting in private shall not of itself be contempt of court, except where the court, having power to do so, expressly prohibits the publication. Section 97 of the Children Act imports the criminal law, save when you're talking to your Member of Parliament, and Section 39 of the 1933 Act is equally well known. Equally, the argument that cases involving children should be heard in public has been taken twice to Strasbourg, and each time failed in the European Court of Human Rights. It's also been litigated in our domestic courts, and perhaps unsurprisingly has failed in those courts too. The thinking of the ECTHR follows Scott and Scott. The following, which I will read to you, is an extract from the headnote to one of the first of the cases cited, be against the United Kingdom. Whilst Article 6.1 of the Convention provided that in a determination of civil rights and obligations, everyone is entitled to a fair and public hearing, it was apparent from the text of the article itself that the requirement to hold a public hearing was subject to exceptions. The present proceedings were prime examples of cases where the exclusion of the press and the public might be justified in order to protect the privacy of the child and parties and to avoid prejudicing the interests of justice. Moreover, it was not inconsistent with the general rule stated in Article 6.1 for a state to designate an entire class of case as an exception when considered necessary in the interests of morals, public order, or national security, or where required by the interests of juveniles or the protection of the private life of the parties. Well, the need for such measures must always be subjected to the court's control. The decisions in each applicant's case, therefore, to hold the hearing of the application for a residence order in chambers does not give rise to any breach of Article 6, subsection 1. The European Court did not consider Article 10 separately, didn't need to, because it said that the prospects of the report being published under English law were remote in the extreme. There is thus ample material for the now universally exercised discretion to hear proceedings relating to children in private, and for the reporting restrictions on such proceedings in the Court of Appeal, which of course sits in public. It's also worth pointing out, I think, that the burden of the Family Justice Review and the government's acceptance of its recommendations was the centrality of the role of the child. We are to be heard a young people's board as part of the government structure for the family justice system. There is abundant evidence that when asked, children do not wish the intimate affairs either of themselves or their parents to be published. And it is said it is not simply a question of the children's wishes and feelings. There was an extremely informative article by Dr. Dania Glazer, a well-known and highly respected child and adolescent psychiatrist, and she made the powerful point of family law last year when opposing what was then the bill that important information might be lost to the court if the child decided that he or she would not speak to the specialist because there was a risk that his or her words would be conveyed to a third party outside the confidentiality of the consultation. In addition, of course, the anti-transparency lobby argue that, particularly at the time of the Leveson report or the Leveson inquiry, it is not a good time to trust journalists with confidential information and expect them to honour it. And there is, of course, the additional problem that cases will need to be identified. Long gone are the days, and this is the point I shall make again, that when it was possible for the press to have a stringer in every court, and nowadays, if we are to open the family courts, we are, I think, going to have to open the courts by letting the people know, letting the journalists know what is on. Finally, on a purely human level, the story still resonates with some people, which was told by Nicholas Crichton, the well-known stipendiary magistrate at Wells Street, who had a fortnight being shadowed by a journalist. At the end of the fortnight, he asked her whether she would, if she had been the mother of one of the children, or if she had been one of the customers that he'd had to deal with in the last fortnight, would she want her affairs heard in open court? And her immediate answer was, no, don't be so silly, of course I wouldn't. So I'm sure those who oppose media access and the reporting of family courts will be able to add to the arguments which I've just set out. But they're quite powerful, and they're powerful arguments in favour of privacy and against transparency. So what's the case the other way? And why is there such a clamour for reform? I'm not necessarily going to take the points in order of merit, but the first point I think must be that the present situation is highly unsatisfactory, particularly from the media's viewpoint. There is of course the right to attend, which I shall come to in just a moment, but there remains considerable doubt about what they can and cannot report. The rules about what they can and cannot report are by no means clear. The right to attend is of little value, they say, even if the cases are newsworthy, if there is no access to the court's documentation, and doubts about what can or cannot be reported. Process is important. If the journalist is denied access to the process and is only presented with the result, how can he or she adjudge the result to be fair, particularly when the person whose child has been removed vociferously is crying foul? There is, I think, genuine acceptance of the proposition that the anonymity and privacy of children should be respected, and that this will in some cases mean the anonymity of adults who have the same surname. But the media's argument is ultimately a very simple one. One starts with the proposition that justice should be administered in public. The press represents the ears and eyes of the public. If the child can be protected by anonymity, why should not erring adults, particularly social workers, experts, and local authorities, be identified? Moreover, not only is a great deal of public money spent on care proceedings in particular, and the public is entitled to know how its money is spent, but the fact is that the fact that the court sits in private enables decisions to be taken without scrutiny and therefore without press publicity. Social workers, local authorities and expert witnesses, amongst others, they say, indeed anyone occupying public office is unaccountable to the media and thus to the public. The argument that their decisions are subject to judicial scrutiny cuts no ice with the media, since the judge's world is seen as at best as passive and at worst collusive. The judge also sits in private and usually delivers judgment in private. With rare exceptions, even judgments made publicly available are heavily anonymised. So the argument runs, subject to the safeguards I've mentioned, why not, say the media, open up the proceedings and hear them in open court, or at the very least, subject to the same safeguards, allow them to be fully reported. In short, ECHR Article 10 should prevail over the rights of the parties under ECHR Article 8. The press can legitimately also make the point, I think, that in other areas of the law they are frequently in receipt of information which they will enable them to name names, but they don't do so. They understand the process as well as the law of contempt better than most. Furthermore, the press argues that when the courts invoke their aid to track down a missing child, or a child has been kidnapped, the press invariably cooperates. So let's put these arguments in context and see where they take us. Two of the press's concerns are, I think, warranted. The first is that journalists simply do not know what proceedings are on. Gone are the days, as I say, when a national newspaper could afford a reporter in every court. There may well be some places in the country in which a local journalist sits in the local magistrate's court or Crown Court and reports his or her local newspaper. But such a system is unrealistic when it comes to family justice. So the media say, and there is force in this, that they need to have access to court lists, and such lists need to provide them with sufficient information to enable them to decide whether or not the case is worth reporting. Subject to appropriate safeguards about the publication of information thus made available, it is difficult for me, at least, to see why that request can't be honoured by HMCTS or by some other agency. Secondly, the press argues that it does not, as of right, have access to the documents, and journalists are thus unable to follow the proceedings. There can, I think, be a lively debate about precisely what documents the press should see and the safeguards which should surround their sight of the appropriate documents. But if the purpose of a sight of the documentation is to enable the journalist, firstly, to follow the proceedings, and secondly, to understand that any tendentious version put forward on one side may be inaccurate, and finally, to further the process of accurate reporting, it's difficult to see, once again, subject to safeguards, why the press should not have access to some of the court's confidential documentation. So, to the charge of sensationalism, the press can legitimately give the answers I have already identified, namely that they are to be trusted, the press is acutely aware of the law of contempt, and whilst frequently possessive information in family proceedings and doesn't publish it unless it is given authority to do so. And also, of course, they will use their organs to assist the courts where necessary to trace a child. Another criticism of the press is the alleged preoccupation with names rather than issues. But here they have the judges on their side, because in a recent case, Lord Roger of Aylesbury, in a citation which I won't give you the whole of, began with the famous phrase, "What is in a name?" A lot, the press would answer. And he went on to give perhaps the best description and the best justification for naming names that exists. And he also quoted Lord Steyn in the well-known case of S, to which I shall come back, saying, "From a newspaper's point of view, a report of a sensational trial without revealing the identity of the defendant would be very much disembodied area of law. If the newspaper choose not to contest an injunction preventing them from reporting, they are less likely to give prominence to reports of the trial. Certainly, readers will be less interested, and editors will get and will act accordingly. Informed debate may well be stifled." Thus, and as I say, these points are not taken in order of merit, the media's answer goes to the very fact that the courts sit in private. And they say that is unacceptable, and even if media access is not barred, then that which can be reported is strictly and inappropriately limited. The whole position, they say, is thoroughly unsatisfactory. The charge of secret justice is thus easy to make and to refute. The fact that both the FJR and the government have praised the dedication of those who work with the family justice system may have eased the problem, but has certainly not resolved it. The fact of sitting in private undoubtedly leads to a number of evils from a judicial standpoint. Because they often hear only one side, usually passionately expressed by the litigant, journalists are, they are unable to redress the balance. Unfortunately, this often leads to judges being introduced into the press for that which they manifestly have not done, allies it always is to what I have in reported cases called a tendentious and illicit leakage of information to the press by one side. The media's answer to this is equally simple. If one side, usually the parents, cries foul, and it cannot publicise the other side because of the adherence to the confidentiality rules and its refusal to comment, what is it the press to do? There are many examples of the phenomenon which I have identified, and one of the most recent and one of the most trying for me was Marie L., a child, which is heard on the 18th of April of 2011 and is available to be read on the Bailey website if anyone wants to do so. In that case, the issue is whether or not the injuries to a non-ambulant child aged 6 weeks had an innocent underlying organic and as yet undiagnosed medical cause, or whether they were inflicted by one or both of his parents. At a fact-finding hearing, after listening to all the evidence, including 5 medical experts from 4 different specialities, the judge found in a closely reasoned initial judgment, amounting to some 193 paragraphs, that the injuries, and in particular fractures which a child had suffered, were non-accidental. The mother had given her version of events to a journalist and it was published anonymously. The journalist was not present in the court at any time and did not publish the judgment. Nevertheless, the judge was severely criticised by the journalist. Equally, when Mrs. Justice Tice delivered a detailed and careful 240-paragraph judgment, this time actually in open court, vindicating parents who were alleged to have killed one of their children, family jurisdiction was taken to task by the Times, no less, the leading article, for hearing the case at all. It was as if the concept of child protection and the difference between criminal and civil burden of proof simply did not exist. Only this week, I've had a case in the Court of Appeal where a criminal prosecution would have been quite impossible, and yet the trial judge found undoubtedly the child had been sexually abused. In April 2009, the rules were amended. Rule 27.11 was made. Rule 27.11(2) permits the, quote, duly accredited representatives of news-gathering reporting organisations, unquote, to be present at certain proceedings held in private. The accompanying practice direction, however, issued by my predecessor, made it quite clear that this did not entitle the media to receive or peruse court documentation without the permission of the judge, and there was no clarification of what could be reported without the judge's consent. The result, as I recall it, was initial confusion. Latterly, as I understand it, the right to attend has not been exercised. I do not think any criticism can properly be levelled at the media for the rule's demise. The situation accordingly remains unclear and confused. So that, I think, accounts for the pressure for reform. The question thus is what we can do about it, if anything. What can we permit? What can we not? I propose to start my discussion of this part of the paper by looking at what Mr. Justice Bumble's then was said in the BBC against Kafkas, when he attempted to summarise the law as it stood at that time, and that is as the law still stands. His first proposition was that where proceedings in relation to children have come to an end, the restriction imposed by the Children Act, Section 97, subsection 2, no longer operates. That is Clayton and Clayton, decision of the Court of Appeal, which I was a party. Secondly, the only relevant statutory restrictions are those imposed by the Administration of Justice Act, Section 12, which I have read to you. Section 12, although it prevents the publication of a medical report and imposes restrictions upon discussion of the facts and evidence in the case, does not prevent publication of the names of the parties, the children, or the witnesses. That's an important point. Fourthly, accordingly, unless the court agrees to exercise what has become known as the disclosure jurisdiction, or a phrase invented by Mr. Justice Bumby himself in Re B, or a medical report which relates to the proceedings cannot be published. But unless the court decides to exercise what has become of the restraint jurisdiction, there will be nothing to prevent the public identification of the author of the report. Both the disclosure and the inherent and the restraint jurisdiction fall to exercise as set out by Lord Steyn in Re S and Sir Mark Potter in a local authority against H. And what Lord Steyn said in Re S, and it's an important point when comparing Article 8 with Article 10, said this, quote, "What does, however, emerge clearly from the opinions are four propositions. First, neither article has, as such, precedence over the other. Secondly, where the values under the two articles are in conflict, an intense focus on the comparative importance of the specific rights being claimed in the individual case is necessary. Thirdly, the justifications for interfering with or restricting each right must be taken into account. And finally, the proportionality test must be applied. For convenience, I will call this the ultimate balancing test. That is how I approach the case in the instant case. Re S was, of course, we remember, attempting care proceedings to protect the subject child from identification as the son of a mother who had been charged with the murder of her earlier children. I will not take any more citations from that case. I think it would be helpful in approaching this issue to look at to see how the Court of Protection has recently dealt with these matters. The first of the three cases I'm going to refer you to is called Re A. It's a decision of the Lord Chief Justice, the Master of the Rolls, and Sir Mark Potter, my predecessor, and it appealed a decision of Mr. Justice Headley, who had allowed journalists to attend court in order to report certain aspects of the particular case. The case in question, you may recall, concerned a pianist who was blind and autistic, but nonetheless was a brilliant pianist and had attained a great deal of publicity as a consequence of his activities. Once again, I will not, I think, in the interest of time, take you through the citations from the case which I have prepared. But I do point out, and it's worth pointing out, that when it comes to the Court of Protection, The court is very much in the driving seat. Not only can it direct who attends, it directs what they can report, it directs how, what part of the judgment can be reported, and so on and so forth. And that power has been exercised on a number of different occasions by judges of the family division. The one I want to deal with first of all, I think, is the case of Re A, which is the decision of Mr. Justice Baker, who again conducted what one would call a classic balancing exercise and came to the view that it was in the public interest for a psychologically fragile mother who'd been arrested on suspicion of murdering two of her children to nonetheless to be named. Unsurprisingly, there was a great deal of public interest about the case. Everyone agreed that the children should not be named, but the question was whether the mother should be, and Mr. Justice Baker decided that she should. In London Borough of Hillingdon against Neary, Mr. Justice Peter Jackson went still further than that and said that in a case involving that particular young man, it was in the interests of justice and the interests of all that the work of the court should be properly understood. He added, not only is this healthy in itself, the presence of the media in appropriate cases has a bracing effect on all public servants, whether in the field of social services or the law, but it may also help to dispel misunderstandings. It is not in the interests of individual litigants nor of society at large for a court that is by definition devoted to the protection of the welfare of disadvantaged people to be characterised as secret or secretive. It is part of the natural curiosity to what other secrets, and using pejorative descriptions of this kind may stimulate interest. The opportunity in appropriate cases to follow a process that has welfare, not secrecy, at its heart can only help the media to produce balanced reporting and not fall back on clichés. Mr. Justice Peter Jackson recognised the reality that the stories about particular individuals were much more interesting and attractive to readers than stories about unidentified people, as I have already indicated from the Guardian News and Media Report case. Equally, however, once the parties' names were publicly attached to the proceedings, the court's ability to protect them or control that information was lost. And he concluded in these ways, I do not foresee any possibility of the court preventing the media from reporting the parties' names at the end of the proceedings, even if everything else that takes place in court will remain unreported. Given the extent of the information already publicly available, it is frankly unreal for the proceedings to continue under the initials as if that offered any meaningful protection. Whilst each case turns on its own particular facts, and Mr. Justice Peter Jackson was at pains to record that this case turned on its facts, one knows whether this is not the way forward. In my judgment, there is, by direct analogy, a public interest in ensuring that the work of the family division is better understood. This is not simply a task of internal working or for legislators. The court protection solution is, of course, very attractive from a judicial point of view. The media can be present. What can be reported is a matter for the judge. This, to my mind, raises a difficult and important question whether in family justice it is for the judge to be the arbiter of what is or is not in the public interest and what should or should not be reported. So I ask the question whether the court protection system can be more generally applied. If the press is allowed to publish what occurs in chambers in family proceedings, notably, nobody, least of all the judiciary, can dictate to the press what part of that material it should publish. That is the element of the freedom of the press. Thus, if it is one thing to say that given material, for example, the identity of the child shall not be published, it's quite a different thing to identify permissible material which should be published. Moreover, the press is faced with a dilemma. It can either report a case as it goes along, or it can be faced with an anonymised judgment, the rubric of which forbids identification of whomsoever the judge chooses. As an example, one of the many difficulties presented by Part 2 of the Act, now about to be repealed, was under it journalists could attend on day one and report the opening of a case, an opening which might bear no resemblance to the subsequent judicial findings. Yet, of course, there was no obligation on the press or the journalist to report the ultimate findings. Thus, the reporting, whilst no doubt accurate, would be unbalanced. Absent legislation or agreement, there is no obligation There cannot be any obligation to report, for example, the judge's judgment or the ultimate outcome of the case. This is a serious defect and undoubtedly in some cases leads to unbalanced and potentially unfair reporting, as I have, I hope, demonstrated. As in the case of Re L. In that case, the judge's judgment was careful and full, the reasoning transparent, yet the judgment, although publicly available, was not published by the newspapers, which had printed the mother's version of events and thus given a distorted picture. There will always be journalists and others for whom the family justice system is corrupt and evil and will can do no right. But am I alone in thinking that there are perhaps a minority, that there are these people are perhaps in a minority? And may I say, dare I say, that a more trusting attitude on our part would produce a result which would be more positive from our standpoint. As I have said several times before, it is, in my view, unacceptable that conscientious judges up and down the country, as they are, administering justice and doing their best with inadequate resources to decide these very difficult cases related to children, should be tarred with the brush of acting in secret. So, it is common ground between lawyers and journalists that there have to be restrictions. There must be restrictions on publication, and there must be restrictions on the publication of children and children's identities. That is a given. Therefore, in many cases, if it may be necessary to afford the adult's anonymity, that is also a given. There will also be always people who I call in the know, that is to say, people who know that they are, who the children are, and who are involved in a particular case. For example, in Hague against Tune, which was not a case about the press, the mother of the child concerned published a great deal of information about the father, which I found to be wholly untrue. She accused him in emails to his work colleagues and to the parents of the child's school of being a paedophile. The hearings in which the father had been vindicated were in private and unpublished. They justified the care order under which the child was living with her father. The matter was complicated by the fact the mother was living out of the jurisdiction in the Republic of Ireland, and that the internet provider who provided most of the details was also out of the jurisdiction in Germany. But in fact, it was in fact the local authority which applied to me for accurate information to be put into the public domain, which I granted, although I refused to name the child. In that case, therefore, there was a great deal of publicity and accurate publicity, because it largely followed the judgment which I'd given, but the child's anonymity was preserved. So I conclude by saying that in a world of anonymous, instantaneous communication, it seems to me that we're going to have to rethink many of our rules. If an expert can be publicly named, why should his or her report simply be redacted, if need be, so as to exclude the names of the children, not be put into the public domain? In the case of X, Y, and Z, I was faced with, following Mr. Justice Bumby's decision in the Kafkas case, I was faced with an application to name the expert. But if I named the expert whose report had been severely criticised by the judge, without giving the expert the opportunity to answer back, how was I to foster debate? Therefore, I directed that the expert's report should be disclosed, and it was. I agree with Judge Bellamy in the BBC against Coventry City Council again, which is reported on the Bailey website, when he said that it was not a proportionate reaction to the ECHR Article 10 rights of the media to prevent them from naming a local authority whom he had ordered to pay a substantial contribution to the party's costs in care proceedings, which they had sought leave to withdraw. He held the risk of breaching the children's ECHR Article 8 rights was potential, whereas the breach of the media's ECHR Article 10 rights was real. The residents of Coventry, he said, had a right to know what their local authority had been up to, and he therefore gave a judgment in which the local authority was named. In my judgment, there is a powerful argument for saying that public authorities, public servants, expert witnesses all ought to be named. My understanding is that Section 12 of the 1960 Act does not, in fact, prevent it. It follows that if the witnesses are named, then they should have the opportunity to defend themselves, and that means putting their reports into the public domain. As far as I'm aware, Section 12 has not been the subject of authoritative interpretation in the House of Lords or the Supreme Court. and there are many technical arguments which remain surrounding it, including whether or not the presence of the media or any other third party prevents the proceedings taking place in private. If an issue is in the public domain or in the public interest, should it not be heard in public? Or at the very least, should not the judgment be publicly available? This is what the Court of Protection has done, for example, in the life support cases. Termination of life by judicial means is a very difficult case, a very difficult matter, but surely a matter of public interest, and surely, in my view, be done in public, provided the individuals can be protected. The judge's judgment should be given in open court, and as I say, steps can be taken to protect the individuals who need protection. I have a great respect for Dr. Glaser and her work, and I see the force of the argument which I set out earlier in this paper. But at the end of the day, I think that the ECHR Article 10 argument would prevail in the example which she gives. That, of course, is a personal view. In any event, the type of case which she describes, I think, is sufficiently rare to enable it to form an exception and for an order to be made in relation to it in the given case. It is, I think, significant that when one another quotation which I think I shall spare you. What may be required, therefore, is not legislation which is at best a blunt and not entirely clear instrument, is likely to give rise to argument, often leading to litigation, as per Part 2 of the 2010 Act, but an agreement that in return for information about proceedings and access to them, the press would not publish the names of parties without the consent of the latter and the court, and that under no circumstances would the name of children go into the public domain. I acknowledge that the arguments are finely balanced, and I note from a lecture which he gave in December 2010 that whereas Judge Bellamy had begun the year as an enthusiast for greater openness and transparency of the family courts, he ended it with questions and doubts. The subtitle of his paper was, "Can the Press be Trusted?" In his view, the jury was still out. His experience in Riel can't have helped him. The trouble with the COP approach is, as I've already indicated, is that it vests the discretion about what should happen entirely with the judge. Whilst this is at first blush is attractive to the judge, it is unlikely to be attractive to the media and is unlikely to operate in family proceedings. The media wish in family proceedings not merely to be present, but to report what goes on. As if a child is inappropriately made a subject of care proceedings, or the court is or the case is mishandled by the judge, or by any of the statutory agencies involved, the media, as the eyes and ears of the public, wish to make the facts known. Thus, the media, for example, will draw a distinction between the issues surrounding the anonymous patient on the one life support machine and the child wrongly made a subject of care proceedings. But I ask myself whether this is a valid distinction to be drawn. Nobody can force the media to publish the outcome of a life support machine case any more than they can force the media to report what has gone on in court, even if the court gives permission for such reporting to take place. So why should the media proceedings under the Children Act not be in the same position as the media under the Act, under the Court of Protection and its rules? If this is the way forward, including letting the press know what is going on and letting them have access to documents, it's going to require a great deal of cooperation from both sides. It also requires the family justice system not only to follow to allow the journalist to be in court, but, as I say, to have access to documentation sufficient to enable him or her to be informed and understand the proceedings. By these means, the media are likely, of course, to learn the names of the parties and of the children. If the purpose of disclosure is the provision of background information, there may well be a strong case for saying that the price of that information being provided is that it must not be published. Is all this possible? I don't know. All I know is that on the whole I would rather have an enforceable agreement between media and judges than an imposed solution by Parliament. Such an agreement may not be possible. Terms proposed by the family justice system may not be acceptable to the media and vice versa. So I don't know the answer to the question I posed at the beginning, but I do know that unless we try, we won't find out. Thank you very much.
Hi, Sir Nicholas. You mentioned at one stage about the right to release medical details but not names. I work in healthcare where people's medical details are sacrosanct. What is that decision based on? Because if you release peculiar medical records details, it's possible to identify someone.
Well, in practice, I don't think so, because you're first of all, you're dealing with a case which will presumably be a local authority case which will have taken proceedings in relation to a particular child. The case X, Y, and Z was a factitious illness case, in which there was a great deal of information in the report, which the expert took the view amounted to factitious illness, but suitably anonymised. But the parents of the children were quite satisfied that they could not be identified from it, the only absolute privilege which exists, we all know only too well, is a legal privilege. You can say you've murdered your wife to your solicitor and then plead not guilty to murder, as I understand it. But ultimately, the judge decides. But the judge would plainly not release confidential information in relation to health or well-being or medical information if there's the slightest possibility that there would be any recognition.
The problem that you raised of press people being in court at the beginning of a case, listening to the juicy opening or the facts as alleged by one side, but then not remaining until the end, and not therefore to be blamed for having been one-sided because they didn't stay long enough to find out what the other side was, never mind what the judge said, is obviously soluble by, as you I think you suggested, by having the judgment alone being capable of being reported. And why isn't that the answer to all cases in the family court, i.e. that nothing is reported during the case, only the judgment at the end, suitably emended for deletion of appropriate names, rather similar to the situation in the civil courts? That would show that the family courts are working and doing their job, show the reasoning, because the judgment has to be fully reasoned, but protect the names of the parties, and in particular of the children.
Well, Michael, I entirely agree with you. I mean, it's a very sound proposition. I mean, there are two answers to it at the moment. And that's the position I would like to see emerge. I would very much like to see it emerge. And I do everything I can to encourage my judges to put their judgments in the public domain whenever they possibly can, if necessary, anonymised. The two answers to it are, I'm afraid, I regret to say at the moment, huge pressure of work on the circuit bench, who literally do these wall-to-wall cases, and no sooner they give them one, they're off on another one. And it is actually very difficult to give a case, to give a judgment, to speak a judgment anonymously. I mean, it may sound silly, but I've tried it, and you think you're going to be completely anonymous, and out slips the name twice or three times during the course of the judgment. And then if it comes back to you you have to correct it. That takes, when do you do that? In your evenings or in your spare time? Well, you could ask the parties to do it. So I think the answer to your question is, yes, as a system I'd like to see, but I mean, it's a long cultural process.
For how long are records of court proceedings kept?
The answer is I don't know. I would have thought it indefinitely. Does anyone know the answer to that specifically? I don't know. I know no mechanism for destroying them. How they're kept, where they're kept, I don't know. But I mean, for some time, yes.
I think that one of the issues that worries the common people is not so much the quality of the judgment, because it's obviously true that you are very qualified people used to looking at all sides of the case, but that the ingredients to the case itself may indeed be suspect, and there certainly have been a number of instances where, for example, medical evidence has turned out much later to be flawed. So the issue, I think, could perhaps be one not only of audit of the judgment itself, but audit of the ingredients of the judgment?
I think that's a very good point, and I think it's very important that we are at the moment in close discussion with expert groups and with government as to the quality of expert reporting, because it is obviously very, very important. I mean, everyone seems to think that judges like miscarriages of justice. I mean, I'm horrified when I have one, and we had one recently where everyone had deferred to the consultant radiologist who read the particular scan, and he had misread it. As a result of which, fortunately, the child went back to eventually to the parent from whom he had been taken, but she had undergone termination in the meantime because she didn't want another child taken away. And you'll be very familiar with the Webster case of Mr. Justice Mumbies, where the children had been adopted perfectly legitimately in a process that was quite unimpeachable. But nonetheless, a grave miscarriage of justice because the parents were unable to have their children back after so many years. So I think the quality of expert advice is of vital importance.
Second bite of the cherry, if I may. The case of baby Peter.
I'm sorry?
The case of baby Pete.
Yes.
Baby Peter. In that case, there was one general practitioner and one medical expert who missed what was happening. They can be professionally penalised because, in my opinion, they were culpable. Is there any legal penalty that can be imposed on a professional, qualified professional?
Oh, yes.
Yeah, I don't think they were they?
I have certainly reported a doctor to the GMC for attempting to mislead me in a case. And he was reported by several of my colleagues too, and as a result struck off because of the evidence that he had given was misleading. I'm not sure, I haven't got the details of the case by head, but I thought the doctors were giving very heavy criticism of Baby Peter's case.
They didn't have to, there was no legal penalty for them. They suffered professionally.
Yes.
But the law, strong arm of the law.
Well, I don't know. No, I mean, apart from a prosecution for a specific criminal offence, there would be no power in the family court except to report to public. If you were misled by or thought an expert, and in fact the rules specifically provide for feedback from the judge on the expert to be given to the expert. So if the expert hasn't done well, or if the expert has done well, the judge is obliged to say. I'm afraid that's often honoured in the breach, not in the observance, like so many of the rules.
If I could just come on to what the last speaker said. Recently, the House of Lords removed the immunity of suit from expert witnesses, so saying that expert witnesses can be sued.
Yes.
Therefore, they have a remedy. They can start suing them for negligence. How well they would get on is another matter, but they can now be sued for negligence.
Yes. Yes, I don't comment on that.
I think I've been chosen for this delightful task because Sir Nicholas and I were at the same primary school. Although he, of course, is much younger, but I can pretty well vouch for the fact that he was a good little boy, judging by the school's celebration of him on the one occasion that we went back. So we know that his start and mine in life were pretty good at this excellent inner London primary school. The entire legal profession is delighted to have Sir Nicholas as president of the family division and able to give us his views. He's known to all of us as really caring about children, and indeed what could be more important now. He's known to all of us as an expert on procedural reforms, which are so important in the family division. And above all, he's known to all of us as someone who is never afraid to stand up to the government and whatever legislative plans they may have in order to defend the rights of the family and, of course, above all, the children. And for that, we should all be very grateful. But I have one sad comment, I think, on his lecture. It's clear that an awful lot of people don't trust the press. Hardly surprising. It's also clear that an awful lot of people don't trust the judges, which is really rather a shame. It's also clear there's a lot of wishful thinking about parents and the fact that if left to their own devices, they will be good parents and take care of their children, which often is not the case, as Sir Nicholas must have seen hundreds, if not thousands of times, as a practitioner and in court. But one thing they're all agreed on, which is that nobody trusts Parliament, which I found even sadder to make the right legislation. And I well remember the debates a couple of years ago, which were cut short and rushed through at the end of the session in that time called a wash-up, when legislation was rushed through without proper consideration about opening the courts. So we are, of course, very grateful indeed to have this, if I may say so, fine family judge and defender of children sharing his experience with us. And we are very grateful indeed. Thank you, Sir Nicholas.
For all information, please visit www.gresham.ac.uk.